The bundles How do you get too many bundles? How do you buy? You buy from 544.
Yes. There's no way.
There's a blackout. And then to get to 5 MB is how much? How long can it last? I think.
Good morning, Agnes.
Good morning, Glenn. How are you?
Put your mic on.
Hello?
Good morning.
Hello?
Yeah, I can hear you now.
Yeah, you can hear me?
I can hear you.
Okay.
Good morning. Good morning,
Good
our
morning.
participants. As we start day one of the Industrial Relations Summit, I want to take this opportunity to welcome you all. And I'm hoping that we are going to have a very interactive session. We have lined up several trainers for you. And for purposes of starting our day today, we'll start with the labor laws, Kenyan labor laws, an overview of Kenyan labor laws, which will be followed. Then we'll have a break from 10:30 to 11. Then from 11 to 1, we shall have the employment contracts, rights and obligations of an employee. Madam Agnes, you're welcome to start. Thank you.
Okay. Thank you very much, Ben, for the welcoming remarks. And the participants also, you're most welcome. And maybe before we proceed, it's important we start with a word of prayer so that we may get strength, energy to go through the training. So I would kindly request any participant to start us off with a word of prayer. Anyone, please? Okay, let's pray. Father, in the mighty name of Jesus Christ, we want to thank you this morning because of the love and care upon each one of us. As we begin our discussion, we want to invite your presence so that you may start with us, walk with us, and end with us. We are praying that at the end of it all, we will have learned something to help us profane our career and the profession ahead. We give you all the glory and honor, and it is in Jesus' name that we pray and trust. Amen. So, participants, once again, I have the pleasure to invite you to this summit to close our year. And I'm happy that we are closing a year when we want to do the right thing in terms of compliance with what we are mandated to do as HR professionals, consultants, practitioners, or any other role we play as we serve people through this noble profession. This summit will be just a learning platform because each organization has its own unique issues. Maybe you are grappling with, you are dealing with, or you are getting challenged. So this is a forum where all of us are teachers, lecturers, trainers. At the same time, we are all students because we have unique issues which we need to come out. And at the end of the training, we will have learned something to help us or make us better performers. And maybe before we begin, as usual, you are free to ask any question at whatever point. You are free to contribute anything that will add value to all these participants. So just feel free and let's interact and share our experiences. And today, we are just reminding ourselves about the labor laws. I'm sure all of us, or majority of us, know about labor laws. Others, it may be new, but it is always good to remind ourselves for purpose of compliance. Right now, we know our doctors are having issues. That is part of non-compliance in terms of labor laws. And of course, you can see when we do not comply, what happens. The people we care for are the ones who suffer because if, for example, doctors have not been provided with the PPEs, there is a labor law which is being violated. And if they are not happy, we can see who is suffering. The human beings we take care of, the patients. And you know, sickness can come to anyone at any given time. Therefore, as HR practitioners, it is always important to try and comply and adhere to the calling and to what we are supposed to do. So today, between now and 10:30, we shall just look at the key labor laws because there are many, but there are some which we must comply to up to the latter if we want to stay in harmony with our employers, our employees, environment, the government, and any other arm of the government. So to start, I want to share our presentation, which will guide us for purpose of moving forward. So I would want to share, and then we shall be guided from there. So that is our guide for today. I hope you can all see. It is starting today up to 10th November, and you are most welcome. So we will be having several trainers because industrial relations are technical, and we need to put together our minds that we do what is right. We do a lot of consultation and we move together. So these are some of the trainers, and we know this is a great leader, Nelson Mandela, and he was fighting for human beings. We know the history. He was a very charismatic leader, and he stood for the rights of human beings. And of course, all of us here are dealing with human beings. That's why we need to comply and ensure that they are having a good working environment. Their rights are not violated in any way. And even us as employees, we do the right thing to ensure the employees are very comfortable. So this is just a motivation and a role model of a good leader. So, and he's saying, do not judge me by my success, because most of us are judged by our great achievement. But for him, he says, judge him by how many times he fell down and got back up again. And every leader, actually, the moment you fall down and you come back, that is actually the success and the achievement. And this is the content which will guide us from today up to 10th. And for this morning, we are starting with the labor laws, just an overview. We are not going into details of each and every one because, of course, these Kenya labor laws are written by the specialists who are the learned people or the lawyers. And the language which is there, we may not be an authority in it, but from the content, we pick and customize through our documents we use in day to day. And also, we may not be able to interpret because law has another kind of language which needs to be interpreted and understood as it was meant. But for us, it's just to understand those acts and what they mean to us as we do day to day work, because those acts produce the activities which we do on daily basis. Then later we shall be talking about the employment contracts, to be taken through that, and then the termination and dismissal, because these are the things which we do on daily basis and bring industrial unrest. And then we'll be talking about ethical issues in the workplace. We know they are there. And from there, we'll have about 3 sessions on judgments which have been based on the violation of labor laws, and they differ from organization to organization. And these case laws or judgments have been done by the judges, because when people go to court, they meet with the judges who interpret the cases and then come up with judgment. So for us, that is not our work. And of course, none of us wants to be taken to court. That's why we need to remind ourselves about these labor laws and what we need to do to avoid these court cases, litigations, and wastage of time, because it can also be very costly in terms of finances, in terms of time, and also if you are not complying with industrial relations, it can have a lot of negative impact as an employer, and you find you are not attracting employees. People don't want to do business with you because either you are unethical and you don't follow the laid down procedures as per the labor laws. And then we will look at finally the emerging issues and the amendment on the Employment Act. We know the Employment Act, which was revised in 2012, there were other amendments which wanted to make the Employment Act better for the good of the employees. So in a nutshell, that is the content which we shall discuss. And the objectives are actually to create awareness on relevant labor laws and the policies to ensure legal compliance, to enable organizations to relate effectively with your employees, your consultants, your vendors, and others to achieve the organizational business. In other words, we want to do what we are supposed to do to avoid unnecessary rankings within the organization, with our customers, and the public at large. And then another objective is to implement appropriate and customized policies as per the needs of your organization. Of course, every organization has its core mandate. So based on the general policies, you pick and customize in order to suit your specific mandate based on your mission, vision, and core values. And then another objective is to ensure appropriate disciplinary process that meets the legal requirement. Of course, we know disciplinary process can have what the lawyers call a lacuna. You may have done the right thing, the culprit may have been on the wrong, but if you do not follow the due process, then the entire process becomes null and void. And you may end up actually paying an employee who has committed an offense, as long as you've not followed the due disciplinary process. So it's important to follow what is required, because when you go to the court of law, the judge will only use a simple word to technically knock you out while thinking what you did was right. So it's important to be very conversant with what goes on. And the final objective is to minimize or even eliminate and mitigate the danger or risk of litigation, institute legal compliance as a business organization, and help your organization to prevail or do well in employment and labor law. So the objectives are very good. They really want to protect you as a practitioner, protect your organization from unnecessary expenses, unnecessary time wasting, and unnecessary court issues, because they can be very time consuming, and the paying lawyers to stand your case or to argue out it for you can be very, very costly. So we are dealing with employee, and the employee life cycle is when an employee is recruited and is brought on board. Right from the recruitment, you do induction, and in between, from recruitment until the employee leaves the organization, there are so many activities which take place and which may bring industrial unrest. So that's why the labor laws are there to guide us, to ensure you get it right from when you are recruiting until when the employee leaves the organization. So the introduction to Kenya labor laws, we know there are so many, but we will just mention a few which are affected. These labor laws are international, and they are borrowed from the international labors where it is globally acceptable. So we borrow them from ILO, and if we narrow down and customize, now we come to our the constitution. So Kenya is a signatory to ILO. You will all remember we have our Mr. Atoli, who always attends those meetings to represent Kenya, and he is one of the senior officials at ILO. And through his interaction, he has really tried to assist the Kenyan organizations to adhere to the acceptable labor laws globally. So this is where we all borrow the labor laws from. They are all customized, and you don't need to know which was enacted when and what it entails in depth. But just know Kenya is a signatory to all these treaties, and it adheres to this, because any labor law or any law outside this, of course, it is not acceptable. So this is global, where the entire world borrows from. And if it goes against this, then it cannot be acceptable. We narrow down the Constitution of Kenya is the supreme law in Kenya, and all other acts, all other activities, all other laws are derived from the Kenyan Constitution, because this is the supreme, this is the mother of all labor laws, and anything outside this, we say it is null and void, and it cannot be acceptable. And everything else which has been created in terms of industrial relations or in terms of anything to do with labor laws, it has to be in line with the Constitution of Kenya 2010 and every other legal law. It has to be aligned and realigned with the Kenya Constitution. And the other act which every HR practitioner should have, it is the Employment Act. It is the overall, in addition to so many other labor laws. Employment Act should be number one, and every HR practitioner, every consultant should be conversant with the Employment Act. It has been revised in 2012, and still there are other amendments to make it even better. So even if you do not know any other labor law, the Employment Act 2007, which was revised in 2012, this is a document which is a must. And as HR practitioners, we should all be conversant and get acquainted to each and every chapter of this and every section, because it summarizes all the practices right from onboarding up to the retirement. Therefore, this is the first one, and it contains general principles of employment from section 5 and all that. And it contains each and every practice that is usually done in the organization. Therefore, all HR practitioners should ensure they understand this, and if there are legal terms which are not clear, they should get interpretation from the lawyers who understand. Because I say these documents are not the normal documents we know. Their language is very technical, and unless you are a lawyer or you are taken through, then you may not be able to understand it. So get interpretation, whether a comma, a colon, a full stop, and all that. Then you find you will avoid unnecessary rancors. So in the Employment Act, it provides the legal provision that relate to the rights and duties of employer and employee. And this is enshrined in our Constitution, Chapter 4, which gives the rights of employees, so many rights. Then it provides also the basic condition of employment, just like other laws which borrow also from here. Then provision of employment contracts, which we shall be talking about later, and then termination of employment. And we know termination is the end of any employment. And again, apart from the international labor laws, we also have mandatory policies in Employment Act. And we are saying these policies, employer have to have non-discriminatory policy on this. This is just still an elaboration of what is contained in Employment Act. And also within that Employment Act, it states another act, sexual harassment policy and the gender-based violence. We know this is an area which has brought a lot of issues in terms of non-compliance. We know there's a lot of gender-based violence, and especially even now during this time, we've had a lot of gender-based violence has occurred, and it is a requirement that if you have 20 or more employees, you should have that policy, and you take through employees, you tell them what it entails. And I know this will be coming later during our presentation. And I'm sure somebody will talk about it in detail. And of course, there should be a policy on that, and it states exactly what is required. And I know that will be dealt with. And again, still through the Employment Act, there is non-discrimination in employment. We know there have been a lot of court issues in regard to discrimination at the place of work. And the Employment Act states clearly that there should be no discrimination whatsoever in terms of the gender, uh, political affiliation, sex, or minority, your HIV status, disability, and all that. It states very clear that no one should be discriminated in any way. The employees need to be given equal opportunity when it comes, regardless of their race, their color, their sex, the language they use, the religion, political or other opinion. It is their right to benefit, and there should be no discrimination at all. Because if there is a proof that one was discriminated, then you end up in a court of law, and you know what that means. When you are doing promotion, when you are offering training opportunities, when you are giving rewards and all that, there should be no discrimination whatsoever. And that one is well stipulated in Employment Act. And non-discrimination in terms of even the pay, equal opportunity, equal pay for equal work. It is well stipulated in the Employment Act. Even there should be no discrimination when you are doing disciplinary cases. It should be fair and to the betterment. So, and actually, there should be a non-discrimination statement in the organization to show that there is a lot of transparency. And we are saying no member of staff shall be discriminated so that another staff member or class of employee is victimized or treated less favorably than another on ground of the race, your color, your marital status. That's why in employment these days, when you are filling the forms, actually nobody is interested in your marital status. Nobody is interested in your religion. Sometimes nobody is even interested in your ethnicity, unless now actually they want to do the balance. And no one is interested in where you come from, because that has nothing to do with the employment. They are looking at your competence and your skills. Some of these things are non-issues, so you should not bother. Are you single? Are you separated? Are you divorced? How many years you are? Unless now it's beyond what is acceptable in employment. This, you look at the current employment forms which are being filled. Some of these questions are not being asked because they are discriminatory in nature. And probably when they ask whether one has a disability, not because they want to deny them the opportunity, but the reason is to see if they can be given an opportunity to ensure they attend the interview. For example, if one cannot see, it is their right also to be called for an interview. And if the person has been shortlisted, they ensure either there is a braille, or if it is a matter of a reading material, the font is good enough. And this is now to ensure there is no discrimination. And for those of you who have been doing advert, you will agree with me, any advert which is done, it should be taken to National Council for Persons with Disabilities to ensure that it reaches each and every person with a disability. Otherwise, you'll be accused of discrimination. So it is, and that is a violation of a labor law. So in as far as Employment Act, that is just an overview, and in a nutshell, I am requesting each and everyone to go and see what it entails. Even if you are not going into the nitty-gritty, even at the list where they have indicated the list, everything is there. If it is employment, fair wage giving, and what hours and all that, everything to do with employment, it is in that act, and get acquainted to ensure you comply. Then the other labor law, apart from Employment Act, is Labor Relations Act 2007. And in a nutshell, this one, which deals with the relationship between the employees, the employer, the state, and any other body. And it ensures there is harmony in as far as work is concerned. This is where we have now the trade unions. This is where we have the issues of negotiating and signing the CBAs. And of course, the essence actually of CBA is to supplement what the management is doing. Of course, there are people who are in union, and it is their right, by the way. Anyone is eligible to join a union. It is their right. And there are other rights in as far as joining the union is concerned. As long as you have followed the right channel, the right process, the right procedure, you've given enough notice, it is your right also to go on strike. But otherwise, if much as it is the right of employees to go on strike, if they do not follow the due process, the due procedure, then that strike becomes illegal. And now that is the purpose of ensuring you adhere and you comply on what it is required. So this regulates the establishment of trade unions, the Association of Employees and Employers. I think I've explained. Employer is obliged to recognize a trade union for purposes of collective bargaining. Because unless now an employer recognizes a trade union, then they cannot be able to sign a collective bargaining. And if it is the rightful union to represent workers, of course, even a union has to be rightfully constituted in line with the act and has attained a simple majority, because also for a union to be recognized, there should be a certain number of members, and then there should be no rival union to represent that category of staff. So if it is a union, also it has also to comply with the labor laws, because if it has no quorum or the required number of members, then it cannot be recognized. They cannot enter into negotiation, and they cannot sign the collective bargaining. So the Employment and Labor Relations, in other words, it is now the Labor Relations Act which has created this Labor Relations Court, and we know what the court does. So it's not important how it is created and how many people are there and all that. What you need to know is there is Labor Relations Court created under the Labor Relations Act. And I think for you, that is what is important. And we are told this court actually is equivalent to the High Court, because the judge who presides over it is a qualified High Court judge. And whatever goes on there, because you are not a judge or an advocate, you leave it at that. But the point here is you try to avoid getting into this labor relations court, because more often than not, and from the experience and from what I have seen, whenever an employee has gone to this labor relations court, they will always prevail. And you will agree with me, because before an employee or a union goes there, they have done their work, they have done their homework, and these labor relations officers, they are very good at this, more than you as HR practitioners. So ensure you comply not to get there, and you can only comply by doing what is expected in terms of all these acts, and ensuring you get interpretation from a legal person who is conversant with the law. So here, the point which I would just emphasize is avoid getting to this court. How it is created, that is not of importance for you. The other labor law, apart from the two we have discussed, is Labor Institutions Act. It was established in 2007, but it has been revised after the Constitution, because it borrowed from the Constitution and inculcated what was important to ensure it is more beneficial to the employees. And this act has established various institutions, and for purpose of knowledge, it has created the National Labor Board, and this is the board that advises the minister on matters concerning employment and labor, and there is also a committee which has been appointed, and also this act has created the labor administration and inspection, and it has created all this. This is just for purpose of knowing what it entails. But what is important here is to know what is contained in this, and what it does, so that you do not do or go against what it entails. But for purpose of information, labor institution, this is what has established, and the key here is matters concerning employment and labor. That's all what for now I should tell you to know. Then another labor law is, we call it OSHA 2007. And in a nutshell, this one provides for the registration of workplaces, safety and welfare of all employees, as well as the other persons who come to your place. Currently, this is a labor law which we are all now trying to comply with. And if there is non-compliance, you can see now like the doctors are having issues, because they say they are not being provided with PPEs as they handle the COVID-19 pandemic. They say they are not provided with gloves, sunglasses, the facial masks, which are transparent, and the gowns they use when they are handling these patients. And as a result, to comply with this, we've seen so many doctors have lost their life. And of course, now that has led them now to go on strike, to down to their activities and all that. And at the end of the day, they are suffering, patients are suffering, and everybody else is suffering. So failure to comply with this has caused a lot of industrial unrest, and we are seeing it. There is still unrest because this labor law has not been complied with. So if they are provided with protective gears, they are willing to work. But otherwise, if they are not, they have to fight for their right. And as they do so, people are suffering, lives are being lost, people are undergoing a lot of pain. So it is important to comply, to avoid litigation, to avoid loss of life, to avoid this stress which is affecting all this. And this is a good example of what is happening right now. Then we have the National Employment Authority Act. This is a recent labor law, which is important, and it caters for the institutional framework for Employment Act to enhance employment promotion, because we know if there is no fairness in promotion, that can bring litigation and it can land you into court. It promotes promotion interventions to ensure people are given fair promotion, they are promoted on merit, and there is no discrimination, there is no unethical practice and all that. And to enhance access to employment for youth, minorities, and marginalized groups for connected purposes. Remember, the youth has been brought on board in terms of employment, in terms of opportunities, in terms of inclusivity in the matters of employment. And of course, we know there are minorities, those people who are never recognized, or it's as if they have been forgotten, and then marginalized groups. At one point in public service, there was an audit which was being conducted to establish the youth in terms of gender, in terms of age, and also there was a column for a minority. Actually, they were telling people to state their tribe and also marginalized. So this National Employment Authority Act of 2016 wants to ensure there is equal opportunity when it comes to employment, that no one is left out, no one is given a raw deal. So it wants to ensure inclusivity in all the benefits, in terms of any benefit that the government provides. And of course, it has replaced this National Employment Bureau, which was formerly a department in the Ministry of East Africa. And this is just for information. What is important is to know there is now the National Employment Authority Act that caters for the youth, minority, and marginalized groups, including persons with disabilities. And the other labor law, which is very important, is the National Hospital Insurance Fund Act. It was created sometimes back in 1966, but it has been improved or enhanced to 1998. And here, what is important, it is the labor law, it is the act, and what we are benefiting from the act is these, the fund, the National Hospital Insurance Fund. We know what it is, how it has been benefited employees, and for you as a HR practitioner is now how you handle the NHIF, because we know it caters for the medical for an employee, dependent. You should know how it operates and ensure you do not know against what it requires. And of course, using now the fund, you know what you need to do as an employer or as an employee. We know now it is open not only to these organized institutions, but even to the public. They are able to contribute 500 to cater for their medical needs. You know how you need to make the deductions, remit them, failure to remit within stipulated time, you know, the penalties, what that calls for, and how it can impact. So ensure if you make the deductions, there is a deadline around 10. If you exceed, either there is a penalty, and that is a loss. Not to mention, your employees may not be able to access uh, the medical services. And also, we are being told currently an NHIF Act number this 9 of 1998 governs the National Hospital Insurance Fund, which is now a parastatal. Initially, it used to be a department within the Ministry of Health, but because of its importance, because we know medical is very, very important. Now it is a standalone fund, which now is created under this act. It has been given actually its mandate with very clear mission, with the vision and the core values. And it has been a very instrumental in terms of enhancing medicine. It has been, there has been a flat deduction of 320 for many years, but now the deduction is based on graduated grades, the highest being 1,700 for those who are earning 100,000 shillings and above, and then graduated based on the income. And we know here the point is to comply with the act. If it says after deduction, remit these funds to the fund by this date. If you fail to do so, the repercussions are there. So ensure you comply. The other Labor Law Act is the NSSF Act. We know after working at one point, we shall retire. And after retiring, there is something which will enable the retiree at least continue with life. There have been issues in terms of pension, because they were bringing the issue of tier 1, tier 2. As of now, this one has not gone through because it was to be deliberated, and there were issues because they were saying, in addition to pension fund deduction, an employee will additionally be deducted 6% and the employer 6%. And there were contentious issues, and to date, they have not been resolved. So they are still being deliberated in a different forum. That is not for us for now. We have to wait. And if there are any further clarification on these proposed deductions in Tier 1, Tier 2, that will be clarified using the relevant also acts and the relevant organization, because I know there was involvement of the Retirement Benefits Authority Act, or the entity as the regulator of all the pensions. There was the private sector, and there were other organizations with better terms than what the NSSF was proposing. So the issues have not yet been resolved, and those who are running pensions will agree with me. You are still continuing, and it has come to a standstill, and it is not for us now to start question. Whatever decision will be arrived at, we shall be able to implement. And since the act originated from the fund, they are the people now with all the information, and once it goes through the parliament, once they have agreed on the way forward in terms of deductions, remittance, and all that, we shall get to know what, as HR practitioners, you are supposed to do at this moment is continue doing what you have been doing. The deduction, whether it is 200 or whichever the amount, ensure it is deducted and remitted to the authority as per the deadline. That's what you need to comply, because if you do not do so, you will inconvenience the retirees, whether it is early retirement, whether they are retiring on medical grounds, whether they are leaving the country, because the point here is anyone leaving the organization and they qualify to be paid their NSSF dues, they should be paid on time. Otherwise, there will be a legal problem, and that is now what you want to avoid. Let the blame not come from you, because you already know the repercussion of not remitting the deductions. That's what you need to know. The rest of the nitty-gritties and what goes on, who constitutes the board, how it is run, that is not for you. But for you, what is your role is to ensure that it is well managed, the deductions are done properly, they are remitted in good time, and nothing is left to chance, so that you are not taken to court by any employee. Remit them to avoid also penalties and all that. And as we continue working, we know accidents occur. And apart from the Occupational Health and Safety Act, which deals with the internal provision of the organization, we have it's called the WIBA, Working Charity Benefits Act. And this one ensures employees are compensated for in case they are involved in accidents, whether within the organization or outside. And within this act, they are given the compensation. And they have also explained what needs to be done, how you need to report this, and the magnitude of the benefit depending on the kind of injury which has been incurred uh, during the working period. Sometimes there are injuries actually which may make someone completely incapacitated that they cannot continue working. This act protects the employees to ensure they do not suffer either partial, total, or any kind of loss while they are working. So it was created through an act of parliament in 2007 to provide for compensation to employees for work-related injuries. Remember, in your place of work, some of you could be operating machines, and these machines accidentally may cause an employee not to continue working. And also there are some diseases which can be contracted in form of either inhaling or as a result of the environment. And some of these diseases actually have long-term impact much later after the employee has left employment. That's why it is important when an employee joins your institution, you test them and find out their fitness. And then again, when they are leaving, you also subject them to medical checkup to know when they are leaving, how they are, because some of the diseases are contracted in the course of the duty. For example, if you are dealing with chemicals, you could be inhaling those chemicals, and over a period of time, one may develop maybe lung-related complications, breathing problems, and all that. And if it is detected in good time, this can be corrected while at work, or probably just before an employee leaves. If there is a complication and it has been ascertained that it came as a result of employment, that can ensure the employee has been compensated. So we are saying this act is to provide for the compensation to employees for work-related injuries and diseases contracted in the course of their employment and for connected purposes. So it is an act which is very good, and everyone should get conversant with this. Probably that chest pain you are having or the employees are having could be as a result of work-related complications. And it's important when you are having medical checkup, you try to find out when did this condition occur, what could have been the contributing factor, and then you try to see if the employee is compensated or is given a treatment. So for that, that's all what we need. And after we bring in the employees, because from the onset, we talked of the employee progress, right from the recruitment, all these other activities in between. Finally, the employee will retire through whichever means. We are assuming here the employee will retire through natural attrition, that is, after acquiring the normal retirement age, depending on your organization. We know in the public sector, the normal retirement age is 60 years or 65 if it is for a person with a disability. Research institutions, the retirement age for researchers is 65 years. For public universities and other research institutions, it depends on what the policy says. And in legal fraternity, the older you become, the better. So here we are saying this Retirement Benefits Authority Act 2012 has established the Retirement Benefits Authority, which regulates the pension schemes in the country. So we are saying, I know in the pension scheme, the defined benefit, the law or the regulation says 30 days after retirement, every employee should get their benefits without delay. And if you don't do that, of course, now you are not compliant and you end up in court. And the essence of labor laws is to ensure we comply, to avoid unnecessary delays, unnecessary litigations, unnecessary arbitrations, unnecessary spending money for no apparent good reason. So the Benefits Authority, RBA, states that retirees should be paid their money 30 days immediately after retirement. So those handling pensions should ensure they comply and they regulate their schemes to ensure they comply with that. And also, apart from that, there are other labor laws which are very important, even though for purpose of this training, they have not been included. But I would wish to share with you so that also you don't land in trouble. There is also another law which is not here, which replaced the former DIT, Department of Industrial Training. That one was handling training matters in the country, but because of now the importance, it has been now a fully pledged parastatal created under the Act of Parliament. So now we are having National Industrial Training Authority, NITA, which now is a standalone parastatal handling all the attachments, internships, training in the country. And of course, we know there could be a lot of discrimination when it comes to internship, attachment, and all that. You find some organizations are not being fair to when students are applying for attachment. You may be showing favorism or not being fair. So that can also land you into court. So NITA is very, very important. And for those of you who are attending some training, actually you find if the organization is accredited, you get refund. And a good example is like SCHRP, the academy which is giving you this training today, unless it has been approved by NITA and also its training have been approved by NITA, it cannot offer the kind of training they are offering right now. And before any training commences, NITA has to give approval and also through the IHRM. So it regulates trainings because not everyone can offer training. Not any organization can offer training. Some are once they are not qualified and they will give you substandard training. So even the training materials, the trainers, the organization itself, it has to be given a go-ahead by NITA. And unless you pay the prescribed fee, you cannot be able to train. And I wish to congratulate this academy because it is fully compliant and then has been very transparent, professional, and open. I see him posting the approval and authority from NITA, even giving the kind of trainers. The trainers also have to be vetted by NITA for purpose of knowing who is doing that, because the academy doesn't need to train unless it has qualified trainers who are accredited. And this is a way of compliance. This is a way to show the academy is doing what is right, and no one can point a finger and say your training has not been authorized, it is not compliant, and it has not followed the due process and procedure. So this is one way of complying with this labor law. I said it is not among what we are discussing for purpose of content overload, but it is very important to know what you are doing now is in compliance with one of the acceptable labor laws. Another labor law which I would want to discuss, though not here, is Persons with Disabilities Act 2003. We know this act was put in force when it was realized there is a group of persons who are out there, they have a lot of skills. It is their right to interact and do all what it entails everyone doing. And from that act, the government has now included them in their institution. And for you not to be sued or to be taken for court for discrimination, we are taught in public institutions, 5% of the employees must be persons with disabilities. And that one is there, and it is also a directive, and it is a labor institution. That's why whenever you do an advertisement, you take it to the National Council for Persons with Disability to ensure now it has reached each and every person. Otherwise, if one is locked out through an advert, you'll be accused and you won't get away with it, and you won't say you didn't know, because ignorance is no defense in a court of law. So any advert you do, take it there and you'll be free. Nobody will accuse you of discrimination, because the CEO of that organization can say these people have been discriminated because they were never given an opportunity to apply for this job, and yet constitutionally it is their right to apply for any job. So take note of this act, National Council for Persons with Disabilities Act 2003. It is part of the labor laws and should not be ignored. Again, there is this act which caters for the HIV and AIDS person. There is an act for 2016. It protects the rights the confidentiality of persons with HIV. They should not be discriminated. They should not be denied any opportunity because of the actual or perceived medical condition. And also, you are aware they should not be subjected to any testing before employment unless they give their express consent in writing. They should not at any one given time be tested without consent because you are infringing on their right and they are protected. So take note. And if you are taken to court and there is a proof that you denied such an opportunity because of the perceived or actual HIV status, then you will be liable to answer. And there was a very good court case for an employee who was denied opportunity because of her HIV condition. And you know how much that organization paid. I'm not going to mention it, but I'm sure you had because it was in the public domain. So let's not be ignorant of some of these things. And then there's another act on the Children's Act. I think it is 2012. There is an act to protect the children's rights in terms of defilement, the work, forced marriage, FGT, and all that, female genital mutilation, and all that. So that is an act, and it protects the interests of the minority and the children, and they should not be subjected to unnecessary. There is also another act to protect the persons who could be abusing drugs and alcoholics. There is an act which was signed into law 2015 by the president, and it protects now the persons who are abusing drugs. In that act, what you need to do and to note is anyone now who comes to work or someone who is abusing drugs, before you dismiss them or before you subject them to disciplinary acts, these people should be treated like sick people and they should be catered for by the medical skill in your organization. They should be taken for rehabilitation, but of course, twice or depending on how you craft your policy. But the point here is the way you treat people suffering from malaria, pneumonia, or any other disease should be the same way you treat a person who abuses drugs, because that is termed as a sick person and they should not be treated in any indecent manner until it is proved that mentally they are not okay. So take note, you should take care of those people through any available means, be it counseling, be it subjecting them to a psychiatrist, or having employee assistance program in place to ensure they are catered for in terms of medication, in terms of any way that can help them bounce back to office. And you should have a policy to cater for such people. So there are so many acts which you need to be conversant with to ensure you are not violating any law, and you need to keep on updating yourself on the best HR practices to ensure you are on course. There are very, very, very many acts which may guide you to ensure you are on course. We have seen of late, there are so many court cases emanating from the organization due to non-compliance. And the level where you are right now, if you do not adhere to this, it will be now up to you. If you give the management, the organization, the board of directors, the wrong information, you'll be personally liable and collectively for any mistake you make. That's why such forums are so important, to equip you with what is relevant. You should also note that there are other issues which have brought a lot of complaints and litigation in employment. The issue of sexual harassment, that one has been very, very, very rampant. And it is very important for all of you to have sexual harassment policy in your place of work combined with gender-based violence, so that you may mitigate. And that policy should ensure that it's cascaded and every employee is aware about it. Because if you violate, there are repercussions as the violator, and also there is the role of the supervisor to ensure that every employee has been drawn and given the repercussion of having that harassment at the place of work. People have been penalized because the sexual harassment has very diverse and long-term impact to employees, and it can affect productivity. And there is an act actually on Sexual Offences Act 2016. And that act states very well and defines very well what is sexual harassment is all about. And it has given forms of sexual harassment. It has given the perpetrators, and it has given the penalties of what happens if one is proven, including jail term for life and very heavy penalties. But the problem with that is most employers, even family members, have tried to hide those crimes, and they try to resolve it amicably, either as family members or even employees. But in law, we are saying a crime is a crime, and it doesn't matter who has performed it. Therefore, also get acquainted to that Sexual Offences Act 2016, because it is an area of one of the labor laws which has attracted a lot of interest, and which is one of the most violated acts in the workplace, in the society, and all that. And therefore, it is very, very, very important that you get note of all these labor acts. They are very important. And what I would encourage all of you to do is get the real meaning and interpretation of each one of them to understand what it means. The problem is when you are handling this and when you are subjecting an employee of having not followed any one of them, you should have the groundwork, you should have the facts, you should have consulted widely to know exactly the real interpretation. Because when you go to court of law, lawyers or advocates have their own interpretation. And if they get it right, even though the employee may have done something wrong, if the process, if the procedure is not right, then you are likely to lose it. And I want to give a good example of a recent case I was reading of an employee of the bank who was accused of stealing a lot of money. True, actually, the court said it is true the employee stole. That was okay. And whoever took the case was right. But then the court went ahead and said, where is the proof that it is that particular employee who stole the money? And there was no proof at all, at all, at all. Because they were asked, was there any CCTV footage? It wasn't there. Was there any other proof that it is this employee who stole this money? Still, there was no proof. So the employee got away with it, much as he stole the money. But then those who went to report did not have the facts. Therefore, before you also go to court, ensure you have done your groundwork properly. And more so if you are dealing with union representatives. They do their work very well. They have all the facts. They go and get the interpretation from the lawyers. So when you meet there during the arbitration or conciliation or whichever channel you are using, they all have the facts at hand and they are able to challenge you. So get acquainted, read a lot, do a lot of consultation, do a lot of groundwork, get to know even what we call the unwritten law. And before you do even that summary dismissal to an employee, find out the offenses you are accusing them of having done and whether you have the proof and whether there is a witness. Because I've realized there are so many things which go wrong when we are dealing with employees. And you can be on the receiving end when on the other hand you should be actually the one trying to defend. Actually, you can be the one to be sacked rather than sacking your employee. So get all the facts right, read a lot, consult a lot, and I still want to emphasize that you are not a lawyer and you do not understand some of these terminologies. But the point is, get to know what you are supposed to do. When you are doing your HR procedures and manual, ensure what you pick is in line with what you are doing. And something else I have noticed about the labor laws is when it comes to training and development. Some organizations, and more so the government institutions, when you are sending your employees out for study, you do what you call bonding and you agree on the terms. But then in between, something goes wrong, you find you have trained someone, you've spent so much money, but if you did not do the proper bonding, and the wording properly. Someone comes with a PhD, and after serving for 1 or 2 years, they just leave with that knowledge, having spent the organization's money, have spent organization's time, having acquired a lot of information, and at the end of the day, that information does not help the organization. This is for simple reason, being that as HR person, you omitted the requirements which tie you with the employee after the training. So you end up losing. And you know, the employee can be clever enough and say, this is what we agreed. So get to know the nitty-gritties of what you need to do. And also, when it comes to the disciplinary, because that is another area where violation has been done, and if you don't comply, also you may not be able actually to discipline somebody, because an employee may argue that they are not comfortable with the people in the panel because of integrity issue, and if they raise it up, the verdict you make can be nullified, because if one of the people in the panel has no integrity, has no ethical practice, then he has no business being in that. Or if one of the committee members is a corrupt person, and there is a proof that that person has been involved in corrupt deals, then he has no integrity to sit and judge someone. And we are having this public complaints office where you channel your complaints if you feel you are not being treated well. Now, if such a complaint gets to that officer and a red flag is raised, then that committee should not continue at all, and it should be dissolved. And it is the right of every employee actually to bring a witness in the disciplinary committee, and the language used should be acceptable to the accused person. So if you are doing discipline, you are using, for example, English, and the accused person is not comfortable with English, then that entire exercise may be termed null and void, because you have not communicated. The accused person has a right to be told why they are being accused, the allegations, and then they need to be given time also to respond. And not only to respond adequately. So in a nutshell, those are the labor laws I wanted to bring to your attention, so that you look at them and ensure you comply to avoid unnecessary court cases, to avoid your organization paying a lot of money as a result of not complying. And finally, we have this inspiring story of Sir Richard Branson. Maybe some of you know, others may not. Sir Richard Branson is the CEO of the Virgin Atlantic Airline, one of the largest airlines in the world. It's a global, huge airline. And over the years, he has been a role model And a good example, whenever you are talking of compliance in terms of labor laws is concerned, he is one person who is very passionate about his employees. And what he says is his employees are the first customers, and he cannot do anything else before he ensures his employees are satisfied. Most of us emphasize that customers are our most important clients. It is true they are. But remember, if your employees are not happy, they are not going to serve your customer. They may pretend to do so, but they will just do so just because they want to earn that money. But in their hearts, if they are not, then they may do it. But from the bottom of his heart, Sir Richard Branson says customers who come first in his setup are his employees. And you may find out how he does it. And if you've ever used that airline, you can tell the way they deal with customers, the way they serve them, and how happy they are. So he is saying clients do not come first. I'm sure most people or most of you may not agree with this, because in most cases, when we are crafting our core values, we say customers come first, but it is the opposite. Of course, he needs those customers because they are the ones which bring business to him, and that business is that makes him pay his staff. But strategically, he has said employees come first. And that is one of the best HR practices. And if your employees come first, even when you are negotiating the CBA with the union, you find actually you are offering over and above what the union is giving. And you find you will never have issues with union at all, because in the current world and in the best HR practice, union people sit down with management, they take tea together, and they are complementing and supplementing each other, because uh, both are fighting or they are having the good welfare of the employees, but of course from different perspectives. But the point is, they are looking and they're fighting for employees. The management is trying to do its best to give the best for the employees. At the same time, the union is also fighting for the rights of the employees. So in other words, these are two groups having common interest of the employees of one organization. And therefore, there should be no point of hitting the table because of disagreement, because you are just complimenting one another. And unlike before, where union people used to be enemies of the management, these days you look at the people who are going to the negotiating table, very well educated people, very well informed people. And when they go to an organization, actually they sit with the CEO and the management, and they are talking of how best they can improve the welfare. Because if we follow and we see an example of this Virgin Atlantic CEO. He has no issues, and I don't think whether his employees have joined any union, because union has no role to play here, because the employees are already taken care, and not only care, very great care by the employer. So we should strive, whether it's a personal business, whether an organization, whatever it is, to bring our employees first, and then our customers will be second. And if we have this mindset, if we have this attitude, honestly, we shall never go against the labor laws, and we will minimize or reduce any court cases or litigation, because we will be working towards the improving of our employees, and we won't have these unnecessary conflict, and especially dealing with the unfairness or unethical behavior or hurting our employees. And whatever we have, we will be using it to further or advance the welfare or the well-being of all the employees. So let's see and let's try to embrace the best practices. And you know, it's a matter of what the management wants to do, because if people go to court, it's because they do not want to do what is right. And that is the nature of man, just being undermined for no apparent reason. If there is no money to do this and this, just communicate, have amicable discussion, communicate in advance why you cannot afford to buy PPEs for your employees. Because if you don't, you will have troubles. If you give them what they want, of course there could be resistance, but as long as it is not extreme, try to work within what is acceptable, even if it is the minimum, and you will avoid all these unnecessary struggles. So let's, from today, after having reminded ourselves about the labor laws, let's see what we can do, even with the limited resources, and we embrace uh, this attitude of Richard Branson, who puts the most important asset first, the employees, then the rest will follow. So he is saying, if you take care of your employees, they will take care of your land. And that is very true. A satisfied employee will also give good service to the customer. And that holds very true. You can only give what you have. If you are not satisfied, even the customers will know right from the very beginning. And even from the organization, you go there from the gate, you can tell a motivated employee. You can tell employees who are happy to work for the organization, because you enter the gate, you find the soldier just trying to eat. He is trying to eat something, and you ask him, I want to go to this department. Instead of taking you there, they will tell you, okay, yes, you go there, take your first right turn, and then you see this, and then you go. All you ask is so and so in the office. I don't know. But an organization where employees come first, you will tell. And I want to give you a good example. Yesterday, when I checked in here, from the reception, I could tell they picked my luggage, we wanted to see somebody, that person, we were taken literally and physically by a lady who took us and showed us where to sit. We also needed something else, and they literally took us where we were. So you could tell from the on, and even the way they were smiling, the way they were carrying us, you could tell these are motivated employees, and they were friendly all through. Immediately, one of the ladies, and maybe I must mention her name, she is Lucy, from this hotel. She told us, you are our visitors from today till you leave. Come and have some lunch. And it was actually past lunch time. We were served lunch. She was so nice. She organized for us to have a room, and we were settled very fast. So from that, you could tell the management of this hotel put employees first. And we were very happy. And with that, I don't envisage any litigations or employees taking now to the employer for any violation, because from the onset you could tell these are happy employees, and that is the essence of complying with labor laws. I'm wishing that we all adopt that and try to adjust how we deal with our employees through compliance with the various many labor laws, which will make our organizations the employer of choice, and everyone wants to join that. And I wish to stop there because time is up. For the remaining 3 minutes, I want to take up any concern, addition, or anything. Then we shall break for tea from 10:30, and then we convene at 11. I wish to thank you very much for your patience, your participation, and listening to me. Thank you very much. Any comment or addition? Hello. Hello?
Yes, Agnes.
Yes, then.
You want me to participate?
Hello?
I'm asking whether you want me to participate.
Whether? Hello? Hello?
We can hear you. Take that. Actors. Temanski, Temanski.
Mambo imekuwa mingi. Then kwanza niende darasani Haya, na huyu anataka ku Hi Eva, how are you?
Hi, but I can see, but I'm seeing you very small. Hello, hi, hello, Ben.
Hi Eva.
Hi.
Yeah, you are ready to, okay, we are moving on now to our second session today, which is, I had explained that in the morning that we are moving to the employment contract, rights and obligation. If any of our participants doesn't have the program, if any of our participants doesn't have the program, I'll gladly share this. They can WhatsApp the admin on 0722 300 245. In the meantime, after this lesson with Eva Magidi is an accomplished trainer with, who has worked with the Tomboya Labour College, but she'll explain herself in a few minutes. We will end our first day at 1 because the main program for those attending in physical attendance, we're having a team building from 2 to 4. So since I would not want to engage you on a virtual team building, I'll share the video so that you'll see what happens when we join physically. But tomorrow we are having a full day, 3 training for the second day, starting with termination and dismissal. Then we shall have ethical issues at the workplace. Then we'll move to the employment and labor relations court judgments, which will take us, that is now from tomorrow afternoon through Thursday. And finally, we'll do the Employment Act Amendment Bill, the highlights of that bill. As you know, it has not yet become been assimilated into the main act of Parliament. So we'll see, we'll cover the highlights. That will be now on the third day. The third day, we shall have the Employment and Labor Relations Court judgments. That is in the morning and the late morning. And then also tomorrow afternoon, we shall have the same topic. It is an extensive topic which will cover issues like redundancy, sexual harassment, and discrimination, protection of wages, taxation of decrease, voluntary early retirement, agreements, application for constitution on employment disputes, Fair Procedures Act, then doctrine of constructive dismissal, recognition of trade unions, application of arbitration clause, and employment contracts. So this is what we will cover in a few minutes. So not in a few minutes, in that sequence. So Eva, I want to hand over the training back to you, and so that we can proceed. Thank you.
Thank you, Dan. Participants, it's good to have you today. We are going to have an interesting interactive session that we are going to discuss about contracts, employment contracts, rights, and obligations. This session is going to run from now until 1. It's going to be a 2-hour session. And I'm also going to share with you the slides which we can follow together to guide us on the discussion. So I welcome you all to this session. When you go to employment or at our workplaces, There are agreements or contracts which we go into that guide us on how we are going to relate with the employees, with the employers at our workplace. And let me share with you uh, some of the issues that we are supposed to cover in this session. I hope you can all be able to have a look at the slide. So we are going first to talk about the employment contract, its rights and obligations. We are going to see what is actually a contract of service, and we are going to compare it to contracts of service. These are normally terms which at the workplace are used interchangeably, but have a very different meaning even in the labor framework. Let's start with the contract of service. A contract of service is actually an agreement between two parties, an employer and a worker. It gives an overall of how their relationship in production, in delivery, in remuneration, in what is expected of each one of them, it outlines. When it comes to contracts for service, this is where an independent contractor is engaged at a fee to carry out a specific assignment or a project. So the first one, there is a relationship, a long-term relationship between the employer and the employee, while the second one, there's the issue of an independent contractor, one, and a specific assignment. Both employees and employers have their statutory rights and obligations under contracts of service. We have what is called like supervision, which is given to the employer, issues of liability, issues of tools of work, how are they going to be used? If there is an issue arising, who will bear the liability and all that? So all this is covered under the contract of service and contract for service. Let's go to the second slide. The Employment Act, the framework that guides employment relationships. It's an act of parliament enacted in 2007. It gives a very clear guideline of the content of employment contracts. It calls them the basic, and they must be captured in the contract that we draw. The first one is the name, age, permanent address, and the sex of the employee. The second is the name of the employer. Then it goes further to say that a job description should be given and outlined in the contract. What duties will the employee be expected to perform? And it should be very specific to what actually he or she should be carrying out. Another very core thing is that it should state the date which the employment is going to commence. For how long? The duration. Is it a 1 year? Is it permanent? Is it temporary? And if it's temporary, for how long? Is it 6 months? And the form that it will take. The terms like temporary indicate the form. The term like 6 months indicates the duration. I hope we are together. The next thing that it should state is the place which this work is going to be performed. We stop. Oh, we stop share. Uh-huh. Oh, we do it down. Oh, okay. Yeah. So we take this machine down. Okay. Mm. The other machine should be maybe I should have put the particulars because I've left some hanging.
Hi, ladies and gentlemen. Allow me. We are moving the trainer to a more comfortable space so that you can also interact with the other people who are participating physically. We have employed top-notch ICT people who will put up a link that is going to really make everything move forward. Thank you for your patience, and let us give us 5 minutes. We will be done. Thank you.
Hello, excuse me, Miss McGarry. Excuse me. Excuse me.
Ameenda na wao na Wekesa yuko, she's alone.
No, let me just I also need to know about Mbona hivi kama
Si nitaka nione mko mzuri.
Unataka kuona tuko sawa.
Mpaka nihakikishe mko sawa.
I think we
Okay. Naita Wekesa.
nitakufunga.
In the end, we have displaced them. Yeah. Sasa najike. Nimesema imana amesikia.
Ni maji. Tulikuwa tunataka.
Tukichemsha.
Acha. Acha nijue hapa.
Ile tu ni hii ya chupa. Inatosha hiyo moja tu inatosha.
Mimi nimejiweka hapo. Kama sitakani kujiweka hapo, nimeweka mavideo.
Internet is unstable. Internet.
Okay, welcome back. For those of you who arrived a bit late, please feel welcome. If we do have an opportunity, we will give you that chance to ask some of those questions. Some people have some burning issues. My name is Ram. I'm a consultant. I specialize in employment and labor law, in particular regulation. So one of the objects of this training is various types of contracts, and eventually how those contracts can be terminated. So a contract is the responsibility of the employer to provide. The about employer says so for those who are my name is the last question the government appointment in 1996. I've also worked with the Federation of Human Rights. I still teach senior citizens more. I also work in 8 different countries, mostly 4 countries. So let us move on to presentation. You recognize this person. You can see this. Okay, as they try to resolve the problem, let's continue with the presentation. This is what Richard Branson had to say about the employee is your most valued asset. If you take good care of the employee, you're dealing with one of the most important. When you tell them about the production, those really come. There's what? Land and what? Yes? How about the is it better? It is better. Okay. So let's be little factors of production. Labor is the most unpredictable. So let's clear here. And some of the So we have to ensure that you have contract you in managing their data. What we are really here will tell you the exact contract and the policy of the organization, but will help you. Some of us are valuing that we did not write down the contract. So the employee can do nothing, especially about domestic health. It is important that no matter how basic the contract is, in the event of an issue, that will help you reduce your liability. So ensure that everybody has a contract. So what is a contract of service? It's basically an agreement between an employer and the employee. Let's see what type of contract. In my contract of service, I was told you that I was going to bring 10 lots of stones. With some suppliers, it is now called use and invoice and paying for taxes. In the first case, is the employer with the agent of the government to collect the tax and to pay the government. That is fair one for the
the one. Although I need to go at the Musawa, you continue. I'll call you if I find you are not attention.
Okay. Greetings, participants. We are very sorry for that hitch. We tried out something, but it seems it didn't work. So let us continue from where we had stopped. We were looking at the contents of an employment contract. We had seen the provisions that are supposed to be there in an employment contract. And we had gone all the way and seen up to the duration of the contract, the forms. And now the next thing that we're supposed to include in an employment contract is the place of work. The hours of work worked. You must specify how long each day the employee is going to cover at the workplace. We also need to say how much they'll be remunerated and at which interval. Are they going to be paid monthly? Are they going to be paid weekly? And how much is it per month or per week? Then any other terms that you feel are envisioned in the contract or you feel they should be included in the contract. But what are some of the obligations of the employer? Employer also has some obligations. What are some of his obligations? First and foremost, it is the obligation of the employer to pay wages and to pay when they are due, to indemnify an employee, to take care of employee safety and working conditions, to make sure that even at the workplace, that the employee is protected from both occupation, any potential hazards, occupational accident, diseases, or any other thing that could happen to him. The Act stipulates that the employer must display a statement of these rights. It must be displayed in a place which is accessible to all employees. But the worker also has some obligations. What are the obligations of the worker? First and foremost, it is his duty to devote and to give personal service. Secondly, it is the duty of the employee to obey what the law calls reasonable orders. These are orders given in the line of duty and which don't violate any law of the land. Thirdly, it is the duty of the worker to make sure there is reasonable care and indemnify secret profits. The new proposed revision to the Employment Act, which is the Employment Act Bill, puts very clearly that the penalty for revealing secrets, and this is supposed to be included in this new act. The fourth duty is what is called duty of fidelity. This means if you are in an industry where maybe you're both producing the same good and service with your competitor, and both of you are well known and well established in the market, it is the duty of the worker to make sure that what he does, his efforts, as he signed them in his contract, are to his employer in the company that he is in the same industry. And there is no infidelity that is carried over to the competitor. That is an obligation of the employee. As we continue, the employee also has rights. He is entitled to what are called basic minimum conditions. They are provided for in the Employment Act, but they are called basic minimum because as we discuss the collective bargaining agreement, we come up with policies, they are due to be improved, but the basic cannot be violated. They are subject to any written law, court orders, CBA, and it is that which provides better conditions. The other right is hours of work. The employee is entitled to 1 full rest day every week. Thirdly, to an annual leave. The law stipulates that the annual leave is 21 days, and this should be accompanied with full pay. Let's be clear here on something. It says you can't forfeit, and it's clear that there is no fulfillment of the leave day. And it goes on to include other provisions. For example, the maternity leave, which goes to 3 months, and the paternity leave, which goes to 2 weeks. Furthermore, we have a sick leave. And there's something I want us to note here. There's a provision of 30 days full pay and thereafter 15 days half per year. When CAP 226 was repealed, there was a provision that any given provision of the new act that is inferior to that which was being repealed, then the one that is superior is the one that remains. And it is from this that we derive the 30 days with full pay, and thereafter 15 days that a worker should receive half his or her salary. Moving on, there's the issue of housing. The law uses the word reasonable. So when you are drawing a contract, it is said that the worker has a right to reasonable housing or a housing allowance that is not less than 15% of the basic pay. The other right of the employee is water, and the law talks about 2 things. 1, portability, and 2, what it calls wholesomeness. The idea is that this should be water that is safe and accessible. When it comes to food, the law is open and says that it is as agreed between the worker and the employer. And this can be included in the employment contract. The employer can go ahead and agree on provision or no provision of the food. Further of importance is the medical attention. It talks that first and foremost, the employee is entitled to the best protected health issues at the workplace, but at the same time, in the contract, the employer should give the employee the appropriate medical attention as it is a right of the employee according to the law. Lastly, any other terms and conditions of employment that are in line with the different sectors. There are special provisions that come in with different sectors. There could be provisions about protective equipment. There could be provisions about hours of work and many others. So it is the right of the employees to enjoy these conditions. I can give one example. There's a provision that in the building industry, the hours of work or the leave days that we have seen in the general annual leave is 21. But in the building sector, there is a specific order that says this should be 26 days. So the employee in the building industry is entitled to those 26 days. Let's continue with our presentation. And we are going to look at what is called non-discrimination. This is a provision of the Employment Act 2007, Section 5. First and foremost, it stipulates very clearly that the employer must have what is called a written non-discriminatory policy. The word here is written, and it is a non-discriminatory policy. Secondly, where the employer has at least 20 employees, employer to have a written sexual harassment policy and procedure. This should be hung in a visible place and communicated in a language the employees can understand. Thirdly, this policy to state rules that are applicable to the employees. This should be referred to them and the provisions from which the documents came from. Another policy that the employer should provide is that the employer should provide written disciplinary policy and procedures. This is where an employer has at least 50 employees. So we saw in the sexual harassment policy, if you have 20 employees, you need a sexual harassment policy. If you have at least 50 employees, you must have a written disciplinary policy. These are the guidelines of the Employment Act. Furthermore, the policy should provide the state rules that are applicable, and it should refer to these provisions of the documents. Let's continue with the non-discrimination in employment. There is something that is emphasized here, that an employer is supposed to put in place all the workplace policies that equate to the following. He should promote equality of opportunity in employment. This is in order to eliminate discrimination. Secondly, he should promote and guarantee equal opportunity of the same and include the migrant workers. These are migrant workers who are lawfully employed in Kenya. Moreover, the employer shall not discriminate both directly or indirectly. Harassment is also an issue that should not arise in the workplace. What are some of these issues that sometimes are the basis of discrimination? They include such things as the race, the color, gender discrimination, language, discrimination again along religious line, political opinions, one's nationality, ethnic or their social origin, disability, discrimination along the lines of pregnancy, marital status, or even the HIV status. So it is the duty of the employer to make sure that there is a strong policy at the workplace that mitigates and makes sure any existing discrimination is eliminated and none arises. Moreover, in respect to recruitment, training, promotions, terms and conditions, and other matters arising out of the employment, so you should not discriminate that these ones need to be trained, these ones cannot be trained. When it comes to promotion, let there be equality. Let there be no discrimination. When it comes to terms and conditions, let there be harmony and there is no discrimination along the lines we have seen above. Lastly, when it comes to a vacancy, how do you advertise for that vacancy? How do you call out for candidates to apply for the vacancy? This should be in a manner that encourages application without discrimination, irrespective of any of the above status. However, the law goes ahead and says, when you take affirmative action, when you are calling out for a vacancy, this is not discrimination. It is not discrimination. For example, you put a vacancy and you say either male are encouraged to apply or female are encouraged to apply. The law says if this is done as a step toward affirmative action measure, then it cannot be termed as discrimination. The citizens should also be employed according to the national employment policy. If there is a certain policy that encourages lines of employment, maybe for the youth, to empower the youth, then that is not discrimination. What about if there is restrict access to some limited categories of employment? For example, the workplace might be interested in certain sensitive issues and they feel that the candidate who gets the job must have certain qualities that are very limited in category. Then the same cannot be said to be discriminatory. If it's stated in the vacancy, then it is legally binding. Let's continue, participants. When it comes to matters of discrimination, the burden of proof is on the employer to prove that there is no discrimination at the workplace. Borrowed from the International Labour Organization core convention, what are called the ILO core convention, there's a very important law that says there should be equal pay for work of equal value. So it doesn't matter who is doing it, their age, sex, they should be paid equally for working work of equal value. Please take note that for the purpose of issues of discrimination, when the law says an employee, it includes applicants for employment. It also includes what we call agents, the employment agencies. So here it is specific and broadens the word employee. It is an offense to discriminate. Here is an example of a non-discriminatory statement. It says, no member of staff shall discriminate so that another staff member or class of employees is victimized or treated less favorably than the other. Okay, the machine went off. So now I'm opening the slide. We are very sorry for that, participant, for the technical hitch. Kindly let us continue. We were talking about non-discrimination statement, and we are looking at this illustration in this slide. It said that no member of staff No, I've shared. Yeah, screen sharing. Ni kama the machine was on timeout, imejizima then.
No, they are on this side, sir. That is on this side.
Okay.
Because now, when you are selecting, nobody can see. Then, the purpose of slideshow.
Kindly let's continue. We said that no member of staff shall discriminate so that another staff member or class of employee is victimized or treated less favorably than another. This also could include staff of a contractor, supplier, or customer. This should not be on the grounds of race, color, marital status, religion, one's gender or sex, ethnic or national origin, or any legal political persuasion. Treatment shall at all times be fair. So this is an example now of a non-discrimination statement. And it goes further to say that treatment shall at all times be fair when it comes to compensation, job security, work experience, recognizing achievement, opportunities for fulfillment, and advancement. Remember we said that there's a burden of proof in discrimination, and the burden of proof was put on the employer. The Employment Act 2007, Section 5 says that in any proceedings where there was contravention of this section, it is the employer who will bear the burden of proving the discrimination did not take place, and that this discrimination was actually an act of omission and is not based on any grounds. So it is the employer who has the burden of proving the same. And remember, we had mentioned that the employee here also includes an applicant for employment. And the employer includes what we call employment agents. But what do we say about employment policy or practice? This includes any policy or practice that is related to recruitment procedures, advertising, the selection criteria that will be used, the appointment, the process of appointment, the job classification and its grading, the remuneration, the benefits and the terms and conditions that the position holds, the job assignment, the environment within which the job is going to be done, including the facility, issues of training and development. Moreover, evaluation of performance and the systems of the same, promotion, issues of transfer, demotion, termination of employment, and disciplinary measures. So these are things that should come out very well in the non-discriminatory policy. And it is the burden of proof lies with the employer in proving all these matters and of them. There has been many judicial considerations when it comes to issues of employment. Many cases have been won or lost on issues of discrimination. There was one best case that took place at the industrial court. And this is what it found. The respondent had actually discriminated on the basis of race. This is because he had less. He had given the same worker a lower pay compared to his colleagues. The judgment of the court then ordered that the respondent was going to pay 12 months gross salary in compensation because they found also that the worker had been unfairly terminated. When all this was awarded, when all the calculations were done, the award amounted to 18 million in cumulative and you can see this is quite a high figure, and that is why adherence to the provisions are very important for any organization, because as we can see from this case study, it can lead to high penalties. There was violation of what we called equal pay for work of equal value. Secondly, the terms of termination were unfair, and this costed the said organization 18 million shillings. So this is a clear case that knowledge and application of the provisions is very important for any organization. Let us look at pregnancy and performance. It is very clear from Section 5 of the Employment Act that pregnancy should not be a basis of discrimination. Section 46 goes further to emphasize that it is unfair, or what is called unfair termination, if the termination was based or connected with pregnancy. And we've seen it carries high penalties if the same is proven. Here we have another case study, and it says that there were too many basic rights that had been infringed. And whenever the employee discriminates, this should not move beyond the remedy of 12 months gross salary. So it means the award or the case we have previously viewed, this particular court judged on the maximum, because the law provides that the maximum is actually 12 months and should not go beyond. Let us cite the actual wordings of the provision. They say, every person has the right to family under Article 45. An employment decision that denigrates pregnancy is an assault on the society as a whole. So this is one sensitive issue and a common line of discrimination, and when proved, is fatal. Are there exemptions to discrimination? We saw in the Labor Institutions Act in the morning that sometimes the law talks of exemptions in its coverage. But what about in discrimination? So under Section 5.3 of the Employment Act, that it is not discrimination to distinguish or exclude or prefer any person based on the requirements of that specific job. The job is unique. It needs some people to be excluded. And therefore, when you exclude these people, the law says, then this is not an act of discrimination. Let us give or draw an example from FOVS International Limited. This was a court case. And let's cite. In the morning when we learned about the sources of labor laws, we said one source of labor laws is previous judgments, and a court can use previous judgments to draw its own verdict. And here, it drew a verdict from a previous judgment of Miguna versus the Attorney General. It alluded to the concern of discrimination in employment, where there were different remuneration packages. So we can see this keep reoccurring, and that is why it is important to adhere to the policies and the law against discrimination. Then, what do we do now when it comes to notification of vacancies? The provision in Section 76 says that this part applies to an employer that has more than 25 employees. So if you have 25 and above, then the notification of vacancies applies to you. You are bound by Section 76. What does it say you should notify? It says that you should notify the director of employment of every vacancy that is occurring in their establishment. Business or work prep. And there is normally a form. There is a prescribed form that you fill that guides you towards this notification. Note is when you have 25 and above employees. Let's look at the particulars. One, it should have employer's name and the full address, the details of the vacant position, the minimum qualifications that are required, and this should be put together and filled in the form. Then a vacancy is said to occur on the date that the employer has created a post. Or when he has decided to engage a new employee. The type of work, you should quote very well. What type of work is it going to be? Is it a casual vacancy? Is it a permanent position? Is it a term contract? Will you work for a specific term, then wind up? And any other such information that is important and may be required by the director. Remember, when the law uses the word may, it's not binding. But the word shall means it is binding and should be included. Then the employer shall notify the termination of the employment. And if anyone is going to be laid off, then it should be in writing. And this should be in the nearest employment service office within 2 weeks of the termination or the layoff. So Section 76 comes out with this guiding framework. Let's continue. There should be a register of employees. It says, an employer shall keep this register, which he shall enter the full name, the age, sex, occupation, date of employment, nationality, educational level of each of the employees, and make a return of employees for each calendar year ending on 31st December. So this is an annual payment and it should not arrive at the desk of the director later than 31st January of the following year. However, the minister can exempt some sectors from the same. Sorry. There is a penalty for an employer who contravenes these provisions on vacancy. It says that you're liable to a fine of not less than 100,000 shillings. You can be sent to jail for 6 months or you can get both. So ladies and gentlemen, that is our presentation. We are very sorry for the few hitches. I hope you've enjoyed and you've understood the obligation and how to come up with a contract and those basic things that you should never miss in a contract. In summary, I will also say we have seen the penalties of not following the basic. It is my hope that as we move forward and go deeper into the content, we will understand more and more of these provisions. It is also our duty as trainees to familiarize ourselves in cases of notices and exemptions. We should look if our sectors fall on the part of exemptions on any of them. We should note and be keen on the vacancies we put across. We should remember that affirmative action is encouraged, youth empowerment, people living with disability empowerment, mainstreaming along these lines is allowed and is not discrimination. Thank you. Dear participants, I would like to use this opportunity to invite questions on an issue that maybe you need clarity or something you did not understand.
Hello, this is Salome. Could you please elaborate on that? Hello, can you hear me?
Yes, I can hear you.
Could you please elaborate further on direct and indirect discrimination? Can you give us examples, please? Indirect discrimination.
You want examples on discrimination from the direct?
Direct and indirect.
Oh, very good. Direct and indirect discrimination. I'll give you two examples of direct discrimination. This is where, let's use the one maybe we had pointed out on pregnancy. There's a workpiece that is being done, and there's a open discrimination against either the one who is pregnant or the one who is not pregnant, in terms maybe of opportunities, maybe training opportunities, remuneration opportunities, and all that. So that is an outright where has been expressed or implied, and it's outright. For example, where it is expressed that I will not send you to this training because you are about to proceed to this, and because you are pregnant. So that one is direct discrimination. Or because you are of this gender, then your pay is going to be less, because I feel that this gender today has done more of the work and not you. Indirect discrimination is where you find, like, for example, there are opportunities for people to retire, and they are being pushed to retire, but it's not outrightly being said, but you can see that it is a certain category which is not outright. It is hidden, but with a keen eye, you can see. Later, when we come to issues of handling disputes and grievances, we will see that there are issues that are very tricky to handle and how to handle them. So it's outright discrimination, but does not come out well. Then there is one that is expressed outrightly, and it's a direct discrimination. Have I answered you, Sally?
Yes, thank you very much.
Okay. Next question, please. Feel free, participants. Let's have an interactive session. Sorry for that. So later we are going to, within the 3 days, later we are going to handle a very interesting topic. And it is a topic called sexual discrimination. So like this one, Sally, we are going to see a lot of that, hidden and unhidden. We'll have illustrations that will help us to understand better. So this will be a topic we are going to handle in our subsequent trainings.
Good afternoon, Eva.
Hi, Melda.
Hi.
Okay.
From what you've just talked about the discrimination.
Yes.
I got the direct discrimination, but I didn't get the indirect discrimination.
Oh, okay. Let me use an illustration of the truck drivers. So you have employed some truck drivers. Just 1 minute, Imelda.
Okay.
Excuse me. Excuse me. Imelda, very
Yes.
sorry for that. No.
Okay, okay.
Let me give you an illustration of the truck drivers. Sometimes you have goods that you are being transported in your company. And I've seen sometimes a truck driver is moving with the goods and he's given the driver and somebody to help them. And then as they move, there's some provision. Maybe when they reach a certain time, they are given some money and accommodation. Sometimes you find that the money they are given could be tailored on their age. This is an example that arose from one of the farms one day. And the employer or the workplace had said that drivers of a certain age were being given less, while the younger ones were being given more. And later, you could not prove that it was being done in terms of age. But with the help, they worked together with the trade unions, and the trade unions tabled a list of all the remuneration. And it was found that the ones who are above this age were actually being given different for the same distance. And the employer there had not outrightly told them that because you are of this age, you're going to be paid this. To take the same good to Kisumu. But the young one to Kisumu, maybe because of some presumptions that the organization had, was being paid different. It was hard to prove, the employer had not said it, and it took more digging and more tabling of documents for it to come out. It was a hidden discrimination based on age. Imelda, does that help?
Yes, yes,
Okay.
yes, yes.
Okay.
Thank you.
Okay. Thank you. Before we were having our discussion and our interaction with Imelda, I wanted to bring out something on discrimination. There has been attempts to review the current provisions of the Employment Act. And the new law is trying to widen the scope, to bring out issues that were not there, to bring out emerging issues at the workplace. For example, the workplace is changing. There are those who are working from home. There are those who are working through technology. There are those who are working on all this. So even these categories of discrimination are bound to be expanded to include such as the HIV status, and also to capture the spirit of the Constitution. Remember, the Constitution came out in 2010. But the labor laws, the core labor laws, the 5 core labor laws, the Employment Act, the Labor Relations Act, the Labor Institutions Act, the WIBA, or the Work Injury and Benefit Act, together with the OSH Act, they were done 3 years before. Now, there are provisions of the constitutions that are wider. They go deeper on issues of discrimination. So even as the labor laws are being reviewed, there's an attempt to capture the spirit of the Constitution. Any other question, participants? So if there is no further question, I hope you enjoyed the presentation.
Hello, Eva.
Sorry. Yes,
Hello.
Brooke, welcome.
Thank you. I'm from Bomet University College, and some of us got in a way behind there. We're requesting whether we could have some slides of the same presentations so that we can also follow through what we have
Okay.
discussed kindly.
The slides come again. You've just joined in?
No, we've not just joined in, but we joined midway. We were not
Okay.
there when it was starting.
Okay.
So it will help us to have the slides for the first presentation so that we can also go through.
Okay, book. I've noted this as an emerging matter, and we'll see over it and we'll give a response soon. That is noted.
Thank you.
Yes. Nasimiu, I've seen your question. Lydia Gadea is asking, what is the case law reference for the first case study on discrimination based on race? So Lydia, let me understand your question again. You are asking, what is the case law reference for the first case study on discrimination based on race? There are two. The first one is on the Employment Act. The Employment Act 2007 outlaws any discrimination that is based on gender and also on the color, whether you're black, whether you're white, or what is your race. But of most importance is the provisions of the Constitution on the same. And let me go back to the slide so that we all follow what Lydia is asking about. Let's go to the slides. So book is asking out of the various content that we have drawn from, and is asking about the first case. I want to see what is this first case. So Lydia, when it comes to the reference on the law, the judge ruled on two cases. One, there was a reference on a previous ruling, which we say it is a labor law can be drawn from a previous ruling, but mostly is from a violation of the labor law. And here outrightly, the issue was on the violation. So the judge didn't specifically draw and say, this is from a previous case, but he noted that it was violation of a legal provision.
Miss Eva. Miss Eva.
Hi, Vivian.
No, you've done an excellent presentation.
Thank you.
I like the sound of your voice and very calming, and you want to teach us. You're like a parent training their child. However, the interruption, I think, has affected the flow of. I feel I need to listen to the recording in a coherent manner.
Okay.
So I don't have. This is a comment. It's not a question.
Thanks a
I don't
lot
have.
for that.
I don't have a question because the flow was interrupted, and in fact, I would have to listen to the recording all over again. But you've done well in your presentation.
Thanks, Vivian. It's good you love my voice, and we are sorry for the hitch. It was those technical hits at the initial, but now we've set our systems in order, and we look forward to a more flowing sessions in future.
What I'm realizing is that this is the future. This is the future in terms of learning. When there are interruptions, it affects someone's concentration. It affects their interest. It affects. Like for me, I was very excited to be part of this training, but I'll stick it out and bear with you and be gracious to you. But it can be very irritating and very. It can depending on where somebody is at. It can affect someone and their concentration.
We're sorry, Vivian. We'll make sure this doesn't happen in future, and we look forward to a very interactive 3-day. And we are very sorry for that. It was technical hitches, and we've worked on them, and we look forward to more positive presentations.
Okay. Is it something that could have been checked beforehand, before
No, it was
the
just
actual
an
thing?
arising matter. Like on the first one, when there was an echo in the room, we had not foreseen that the room will produce some echo. So when we connected, we realized that our participants online were not getting the audio clear. So for now, we've learned this, and we've learned from our mistakes, and we look forward to a good tomorrow and afternoon.
So we'll have you again?
Tomorrow, you want to see me, Vivian, tomorrow?
I want to hear your calming voice.
Okay, that's good one. I'll make a deal. I'll be here, and let's interact more. Actually, when we interact, we are also learning. Even as a trainer, I learn a lot from you also, even from the questions when you bring them out and the examples. So I'm very happy and look forward. And if there's no other question, Vivian and all the rest, I would like to enjoy our afternoon.
All right, thank you. But it feels like the presentation was very short.
Yes. On the one we had this afternoon, after the second one on the contract.
We were meant to have a session from 8:30 to what time? I don't have the timetable. It was 8:30 to 10:30, then 11:30. It just feels short. I think I thought it would be longer.
Okay, because we'll work on this because of the hitches, and it will get better. And then also, Vivian, at this level, we wanted to have an introductory note. And once we understand the skeletal part, then now we go deeper and deeper. And we've tried a lot to compensate for the hitches. And at least you can see we didn't finish at 1. At least now it's going to 1:30, just to have more interaction and cover for the hitches.
Okay.
Yeah.
Okay.
So all the best participants. Something else, Vivian?
No, I'm talking about the time issue. If someone says 8:30 to 12:30, someone might plan something else for the afternoon. So spilling over, someone may not be available to follow.
Okay. That is true. That is true, and it's noted. We promise to get better to efficient and effective. And things will be okay, Vivian. And I know we are going to enjoy a lot the training, and we'll come out of this quite empowered and knowledgeable.
All right. Thank you.
Okay.
We are lending you grace.
Sorry?
We are lending you grace. However, we expect excellence.
Okay. Okay. Thank you. Thanks a lot.
Okay.
So let's interact more. The more we interact, the more we learn. Let's ask questions once we have the sessions. Let's be lively and we look forward. And so any other matter, any other arising issue? No, I have 2 emerging issues and I've noted them and we'll work on them. Any other last one? Okay. So if there is none, participants, it was good to have you. Enjoy your afternoon and I look forward to meeting you in future. Thanks a lot.
Because he was very expensive.